SB 303 by Senator Wieckowski. Good afternoon, Senator Wieckowski.
Madam Chair and members, let me start off by accepting both the author and the committee amendments laid out in the analysis and thanking the committee for their work on a bill that doesn't involve an HOA. No, excuse me. With these amendments, SB
Not this one.
Yeah, not this one. SB 303 clarifies existing law, which generally protects the conservatees' government benefits from being used to pay conservators' fees. Additionally, the bill strengthens the statute concerning the sale of the conservatees' residence by requiring a showing of clear and convincing evidence to the court of the need and benefit for the sale. The importance of a home cannot be overstated. While the sale may be necessary in certain cases, we must ensure that it is actually in the best interest of the conservatee. SB 303 will increase protections for two of the conservatees' essential assets, their benefits and their residence. And here to testify in support is Venus Giss and Curtis Child.
Good afternoon. 2 minutes each, please.
Okay, good. Good afternoon. My name, like he said, is Venus Gist, and I'm strongly in support of Senate Bill 303 due to the abuse of my elderly parents' finances and the plundering of their estate by the Alameda County Superior Court Conservator Michelle Tiernan and her attorney, Ruben Sundin, who is now commissioner in the same probate court. My mom's temporary conservator is a member of the PFAC. This PFAC member was appointed to become the successor trustee of my family's living trust and collected Social Security benefits after my mother was released from the temporary conservatorship of the person. The Alameda County Superior Court judge awarded approximately $60,000 in fees for a 90-day temporary conservatorship without inventory and failure to provide our family an updated, itemized accounting of the correct fees owed. Fees claimed to be owed fluctuated from $10,000 to almost $60,000 after the judge dropped the temporary conservatorship case in February 2018. Upon the termination of the temporary conservatorship, while my mom's SS benefits were being seized with the court's approval, an apparent violation of federal regulation, family was forced to provide for food, putting a burden on the rest of the family. As successor trustee, the conservator served a notice of proposed action on my parents and the beneficiaries of the family's trust, threatening to sell my parents' property worth $800,000. This was after the conservator and her attorneys took most of their fees, and the balance left was just $17,000. The capital gain tax alone would be a couple of $100,000. My parents' civil rights were gravely violated. I urge you to vote in favor of SB 303 to protect our elderly and dependent adults from abuse of their assets. Thank you.
Very much. Next witness, and I'm sure there are a lot of stories where I know of some myself, and this is a very difficult area where there tends to be significant abuse, and I'm not sure how we fix this problem, but this certainly, I appreciate your testimony. Next witness.
Madam Chair, Kurt Child, Disability Rights, California. And as you know, there's probably nothing that may be more important to a person who has to have a conservator to handle their affairs than their home and their public benefits, perhaps family as well. But those are two very critical things in their lives, and mostly because that represents independence for them. The person's home really does represent a place of security, a place of a lifetime of sacrifice to get that home. And importantly, the disposition of that home can often relegate a person to confinement in an institution with no alternative if the person should be able to be in a position to leave the institution but not have a home to return to. So we think really that determination for the sale of a home of a conservatee should really be held to the highest standard. And this bill does that by making it subject to clear and convincing evidence. That's the only reason the compelling reason that would satisfy losing one's home to the hands of the conservator. Second piece of this is ensuring that a person's public benefits, and often this is Social Security and or SSI benefits, those are intended by federal law to be used for the benefit of the individuals and not for fees of others, except for often where that representative payee provision's there for $43. And we think this bill makes clear that only those portions of the public benefits that are otherwise authorized by law can be used for those and protecting them for the individual. We urge your aye vote.
Thank you very much. Other witnesses in support, if you'd come up to the microphone, give your name, affiliation, and your position of support.
Linda Kincaid, Coalition for Elder and Disability Rights, and daughter of conservatorship victim Carol Hahn. I ask your support.
Thank you.
Rebecca Gonzalez, National Association of Social Workers, California chapter in support.
Thank you.
Richard Calhoun with Cedar in support.
Thank you. Any other witnesses in support? You're waving. Is that support, opposition, or? Tweener. Tweener. I'll know that next time. Meh. Okay, go ahead.
My apologies, Madam Chair. Jason Eichert with Edelstein, Gilbert, Robeson, and Smith on behalf of the Association of Public Administrators, Public Conservators, and Public Guardians. With the amendments agreed to today, glad to go neutral on the bill. Thank you.
All right. Very good.
Connie Delgado on behalf of the County Behavioral Health Directors Association. I want to thank the author and the staff for taking amendments. With that, we remove our opposition.
Very good. Are there any witnesses in opposition? Still in opposition? All right. If you'd come forward. Good afternoon.
Good afternoon, Chair and members. My name is Jerry Desmond, and I'm here on behalf of the Professional Fiduciary Association of California, a trade group started in 1994, co-sponsored the legislation that established the Professional Fiduciary Act, a licensure and examination and education scheme. We have 455 members that are licensed. And I'll offer first off that we see the amendments. We haven't had a chance to digest them and give our formal removal of opposition or whether our concerns remain, but I could highlight what I think we see addressed. And to say, to start with, as PFAC, that the protection of the best interests of the conservatee are utmost, and that is a guidance that should provide to everybody that's involved. We also would like to acknowledge, as discussed in the analysis and in preparation for the amendments that the author is taking, which we much appreciate in the committee's development of the amendments, that there's an attempt to acknowledge issues that are brought up in our opposition. First is the rules of the court and the laws that apply in these situations. The second is to make sure that there aren't unintended consequences. The unintended consequences being that a person who is a conservatee doesn't get the care they need because, as introduced, the legislation would have prohibited any government source of funds to pay for a conservatee. And then if I were to highlight a couple of the issues that we see and that will inform us as we look at the amendments, which we acknowledge and appreciate, it's statutes and court decisions and rules of court that are in the committee analysis. And just to mention the three, and then I'll conclude my 2 minutes. One is the rules that apply to the role of the conservator in conservatorships, and that is to exercise diligence and care in these situations, as Probate Code 2401. Another is the role and responsibility of the courts, and as mentioned on page 3 of the analysis, it's to diligently scrutinize the actions of the conservator or the guardian, and we appreciate that. And then third is the issue of compensation. And the analysis states that on page 3 again, that it's to ensure that they are not that they are justifiable and reasonable, and that there is a good faith belief in the appropriateness of them. And then finally, in the rules of court, having to do with the criteria to evaluate whether the compensation is just. While there is a list, two that come to my mind that talk about the situation here, is that the compensation is to the benefit of the conservatee, again, the utmost interest that we have, and also that they are necessary. So with that, seeing the amendments, we acknowledge the effort to blend in the role of the courts, which we think is utmost and appropriate, and then also to make sure that there is a reasonable basis for the limitations. And also note that as we look at the first set of amendments, addressing the preponderance of the evidence for whether the residence is the best place for the conservatee. We know that there might be some work moving forward in terms of what is compelling evidence. What is the compelling evidence to address the presumptions, and also to define that and to address what if there is the consent of the conservatee, and those are also mentioned in the analysis. So we appreciate the opportunity to participate in the process and look forward to working with the committee and the author and the proponents.
Thank you very much. Are there any other witnesses in opposition? All right, bringing it back to the dais, I want to jump in here. I have seen a number of cases. You know, conservatees are frequently people who are either physically or cognitively disabled. The notion that a conservatee might say, yes, sell my house, may not very well take into account they have nowhere to go. That there are very few centers, sadly, to address the issues that people suffer with dementia or other forms of cognitive challenges. So I think that I appreciate this bill acknowledging that people who are conserved usually for a very good reason, and that they are people who truly need that assistance, and that we do have, whether it's public guardians or conservators, people who are very good at what they do and care about the people. And then we have the courts, and frequently the judges are kind of between a rock and a hard place here without enough time to really study each case. But after a while, you say, oh, here comes another conservatorship case without really having the ability to appreciate the experience of the individual conservatee or the experience of the conservator. Sometimes they're family members. Sometimes there's a lack of funding, and there are certain needs that are required. But certainly in today's world, as we become an aging population in California without the infrastructure to house our senior population, the more we can house people at home, the better for them and the better for our society. We just don't have room for these folks, and we don't want them out in the street, which is where a lot of seniors are ending up these days. So appreciate the protections. I think a clear and convincing standard. It's a high one, but I think it's appropriate given the circumstances and the things I've just mentioned. Also, the use of government funds. You know, for a lot of these people, this is it. The choice between dog food or cat food or medicines and all, and yet there's that sweet spot because we want to have people who are willing to appear before the court and act as the voice of these individuals. So I do appreciate this process. It is an imperfect one at best. The stories are legend out there, and I know many of them myself, but I think this really does go a long way, and so I appreciate you bringing the measure, and would open it up if there are any comments. Motion by Senator Monning. Any questions? None. Would you like to close?
I urge an aye vote.
Very good. Thank you. And with that, we have a motion do pass as amended to the Senate floor. Please call the roll.
Jackson?
Aye.
Jackson, aye. Borges? Aye. Borges, aye. Allen? Allen, aye. Caballero? Caballero, aye. Jones? Monning? Aye. Monning, aye. Stern? Umberg? Wykowski? Aye. Wykowski, aye.
All right. The bill has 6 votes. We'll leave the roll open for the absent members. File item number 5, SB 303. The vote count is 6-0.
Jones?
All the absent members.
Jones?
303.
Jones, aye. Stern? Umberg? Aye. Stern, aye. Umberg, aye.
9-0. The vote is out.